Hello, everybody. I am Samantha Flattman, Managing Director of WeAreAllEssential, and today I am very pleased to be joined by Chris Weisdorf, who is one of our legal advisors within WeAreAllEssential. And Chris is not a lawyer, but he is so well versed in the law, and he's actually currently advising part of the legal, advising Adam Skelly's legal team around evidence and such. And so very happy to share his perspective with you. And the reason we're doing this interview is many of you may have seen some of our members exercising their rights to operate their businesses under common law. And that is one approach that some of our members are taking. However, there are many other members within our network who are exercising their rights within the Charter of Rights and Freedoms. And that's where Chris comes in. He's really been invaluable to our network when it comes to understanding our Charter of Rights and which sections to really to state and to exercise. So without further ado, I will present Chris, and I would love you, Chris, to just share a little bit about the key sections that business owners should be aware of, and how you would advise them to go about opening up their businesses under those terms.
Okay. Well, just to briefly summarize, my, who am I and my experience, and why am I even talking about this stuff? I don't have in terms of legal training. I really don't have any. So to be very, very clear right off the bat, I'm not a lawyer. I'm not legally trained. I cannot dispense legal advice, for pay or anything like that. I don't think anything here can be construed as legal advice. I will tell people to retain a lawyer if engaged in any type of legal proceeding. So I'll start there and say also with respect to my knowledge and experience, since if I don't have legal training, how can I speak on to any of this? Well, I took a case all the way to the Court of Appeal for Ontario back in June. This was a 2-year legal battle with the City of Toronto. I lost. You can read about that on Off Guardian. That link will be posted at the end of this interview, written by Rosemary Frey, who I believe is one of the foremost investigative reporters there is right now on COVID. So you can look at that, look at my court documents, read her stuff. In terms of where we are today, there are lockdowns in effect all over the planet. So it's not just in Canada, not just across Ontario or 1 or 2 provinces, but all of them. They are locked down. There are movement restrictions in some provinces. These restrictions are blatantly unconstitutional. They have yet to be challenged here, to be heard in court. Various legal challenges were brought literally within 24 hours of each other, December 9th and 10th, by the Justice Center for Constitutional Freedoms out in Alberta. So there are challenges right now in Manitoba, Alberta, BC. There's also another one, Rebel Media, in Saskatchewan. There's one here in Ontario, and then there's Adam Skelly's case, which I'm involved with as advisor on evidence. So it took, however, what's negative about all this is in the United States, the first constitutional challenges there against lockdowns were launched all the way back in April. They were launched here in December. So we're about 8 months behind the US. And in the US, a lot of these constitutional challenges are still before the courts. They haven't been heard yet. There has been some good progress made there. A lot of our success in Canada will sort of depend on how some of these lawsuits are heard in the United States. But there's been some very good progress made, and probably the best case of all that's been decided was in May. It was brought in May, but it was decided in September in Pennsylvania in federal court. And so I believe that that's the type of challenge that people should be pursuing in the various provinces here. So how do we proceed here? If you're a business and you've been affected by a lockdown, and unless you're a Costco or some large business, you probably have been. That's the whole point of We Are All Essential. We are not just called We Are Essential. We are an essential block to challenge the government's policy and blatantly illegal and unconstitutional laws regarding the lockdowns. which were implemented to begin with absolutely zero evidence, none in animal trials, not with rats or ferrets or monkeys, let alone humans. They were never implemented. They were never proven to work and have never been proven to work. They cherry pick in terms of the evidence and saying, well, they've worked in Australia and New Zealand, but they haven't worked in 180 plus other countries. So it's complete nonsense. So all of this is, in legal terms, what we call a fruit of the poison tree. So in terms of the evidence, usually it's in terms of evidence they call fruit of a poison tree. So if you illegally obtain evidence, everything from that point on is illegal in front of the court. Well, that's what they did. They presented some sort of a health policy, wide-ranging across the entire planet, with zero evidence, with no peer review, no data, no evidence, no nothing, not a single study, nothing, saying that we've got to use it. Well, why would that be? It's never been done before. So, and on top of that, then they use specious grounds for enacting emergency powers. So I told Samantha right before talking about this that there's a process here that the government's used to go after businesses to enact the lockdowns. The first things that they used were emergency powers. Now, they tried to use emergency powers at the federal level under the Emergencies Act. That failed. It failed at the narrowest of grounds, because literally one MP, Scott Reid from Eastern Ontario, he showed up, he said, uninvited, he showed up, he said there's going to be a debate. Because that one MP showed up, the Emergencies Act was not invoked. Thank God for that. If we had the Emergencies Act invoked, we'd have troops in the streets right now preventing people from leaving their homes. I'm not kidding about that. It would be very, very serious and devastating. And most countries have federal laws, emergency powers, and that's why they're in such bad shape. In the United States and Canada, federal laws under emergency powers have never been enacted. So what happened was the provinces enacted their own emergency legislation. Then after that, or concurrently, they enacted various health powers under their various health acts, again, all provincially. So in Ontario, it's called the Health Protection and Promotion Act. I think it's called the Public Health Act in Saskatchewan. Anyway, it's the same thing. They're provincial health laws, and they can make the medical officer of health or chief medical officer of health of the province, as well as the medical officers of health in various jurisdictions and various municipalities, can make orders under these acts. In Saskatchewan, it's all be done by the chief medical officer of health. In Toronto, across Toronto and various other regions, be done by medical officers of health, as well as the chief medical officer of health. So that's the second thing they did. The next thing they did was, in some provinces, but certainly not all provinces, but in Ontario and BC, they enacted COVID-specific legislation. In Ontario, they enacted something called the Reopening Ontario Act, which effectively declared a permanent state of emergency in Ontario. And I'll repeat that again, a permanent state of emergency. It is something that's never occurred before in a democracy, and it is extremely serious. And when it passed, it was invoked came into force in July 24th of 2020. Randy Hillier, who's in the legislature here, called it the Death of a Democracy Act, and I call it Ontario's Enabling Act. An Enabling Act referring to the 1933 legislation in Nazi Germany to invoke a permanent state of emergency and to concentrate all the powers into the executive. In that case, it would be the Fuhrer. And I don't think I'm overstating things. This is that serious. When you have powers concentrated in any one branch of government, three branches being the legislative branch, the judicial branch, or the executive branch of government, when powers are concentrated in any one branch, it is indistinguishable from tyranny. This goes back to 1788 in the Federalist Paper number 47, which gave way to the Bill of Rights in 1791. So this goes back a long time. There's been a lot of thinking on this, called the separation of powers. Doesn't come up a lot in Canada. And in the United States, it does. And all the stuff is being done by executive decree in the United States. In Canada, it's a lot more depressing because they haven't had to use executive decree. They just shut people up. Anyone who dissents is kicked out of the party. If it's Derek Sloan in the Federal Conservative Party, or if it's there's Roman Baber here in Ontario, or there's Randy Hillier, he was kicked out before, he would have been kicked out regardless. And then you have Belinda Carahalios, who was kicked out. Anyone who dissents is out. There is no dissent. There's no debate allowed, and that is not a democracy. It is not freedom. It is not a free and democratic society. It is downright tyranny. So in terms of what your rights are, I think I've laid out the sort of the background in terms of there is no evidence for the lockdowns. None of this stuff is being challenged in court yet. Anytime some medical officer of health in the United States or Canada has appeared in a legal proceeding and is being cross-examined, meaning isolated, put on the hot seat and peppered with questions, they've all been obliterated, including Eileen de Villa here. None of them have survived a cross-examination. The question is, you need proper legal questions posed before the court with a constitutional challenge where the Constitution provisions in the Charter, which is part of the Constitution, our most basic rights, the supreme law of Canada. Nothing can supersede or circumvent the Charter. Nothing. You cannot get around it. So the fact of the matter is, within your charter rights, this is the next part. I've gone over some of there is really no evidence to support that lockdowns work. There's just far more evidence to support that they do not work, that they're harmful, and that they're irreparably harmful and devastating to not just business owners, not just to the economy, but to people's mental health and many other second and third order effects that are caused by the lockdowns, not just the primary of shutting down business. There are many other second and third order effects that result from the lockdowns, and they're absolutely devastating. So how do we deal with this stuff? You have the Charter. Now, I put together a document for We Are All Essential. And I put it together literally just before this tyranny. And I got to shut down this one thing here with respect to notifications that I'm getting via Telegram, unfortunately. But I just brought up the document. And the document is called, and I constructed this document right before the state of emergency was enacted in Ontario. I sort of saw something coming with the language from Doug Ford and various other people here, and how the media was, continuing to stir up a fervor, as they always are every hour of every day. So I put this together kind of anticipating, well, what could possibly happen? And I'm going to just very quickly just list the sections and then go into the one that affects businesses. The first one is lockdowns, then there's forced testing, forced vaccination, travel restrictions outside of Canada, travel restrictions or checkpoints inside of Canada, forced quarantine without symptoms, and then actually that would be it. Yeah. So the one that for the purposes of this call that I'm going to address are simply lockdowns, and that's with respect to any legal challenges today. There's the lockdowns, and now there's the forced quarantine. Those are the only, and forced testing. Those are the only things that are before the courts right now, or about to be before the courts with respect to the quarantine camps. We're, of course, limiting the scope of this discussion strictly to lockdowns, and with respect to Adam Skelly's legal challenge, that is strictly regarding the lockdowns. So what are your rights under the Charter? I've given some of the evidentiary basis of which there is none supporting the lockdowns. I've given I actually haven't gone into the emergency stuff, but one of the keys to the emergency orders made in every province, again, it's all provincial, so every province is different, but every province is the same. They've all said that there's some kind of severe emergency affecting public health, and they have a right to enact emergency measures. But within every public health act, and within every, whether it's the Public Health Act or even Federal Quarantine Act, or whether it's the actual Emergency Act, there is something called reasonable alternatives. So if there's a reasonable alternative to emergency order, they have to use the reasonable alternative. They cannot go to the emergency order. They can't make an emergency order and affect the lockdown if there's some alternative to the lockdown that is reasonable to prevent the spread, in this case, of a communicable but not virulent disease. It's a communicable but not virulent disease. And there are a lot of things that are communicable, not virulent, and we haven't ever resorted to any type of measures like this before. So I will go into the Charter here and say, well, how do we fight these things? Well, the number one thing with businesses is you're going to be cited under there's going to be regulatory, and there's going to be like regulations made pursuant to a statute. So there's going to be, you're going to either be cited under some sort of, well, it's going to be one of three. It could be all of three. You in Ontario, you're cited under the Emergency Management and Civil Protection Act, the Emergency Act. It says violation of order. That you could be cited under the Reopening Ontario Act, which is that permanent state of emergency Ontario's enabling act. You could be cited under health regulations. If you're a business, you could be cited under any of those three or all of those three. All of those three, with the exception of the Health Act, goes before a justice of the peace. It goes into the low provincial court. In criminal court or quasi-criminal court, here it's the POA courts, Provincial Offences Act courts. In BC, it's similar, and every province is similar. So what happens is this is what's supposed to happen, and this is what's happened thus far with every business owner. They will ticket you first. You get a ticket, you look at the back of the ticket, you follow the instructions, and you file for a court date. You say, I'm disputing this, and you file for a court date. I don't know how it is in other provinces, but in Ontario, the POA courts have been backlogged going back literally for about 9 years. 9 years. My lawsuit against Toronto revolved around the backlog in the POA courts and how they removed our rights because of a backlog. With respect to how you stand in Ontario specifically, this works to your advantage. It means that if you get a ticket in Ontario as a business owner or anyone else, and you fight the ticket, you just say, I want to appear in court, and you file it electronically, which you can do now. I believe you can now. I know early on you could not, and you still cannot. But with new tickets, I believe you can. I'm not sure. So you follow the instructions. Bottom line, if you can electronically file, do so. Request a court date, and you will not likely ever see the inside of a courtroom. If you do, or if you get a court date, then again, you, as a block, WeAreAllEssential is essential to preserving your rights. Please join WeAreAllEssential, and you will have counsel provided to you for free. This is the best. This is the best offer that you can get, that you cannot possibly refuse.
And just to be clear, we
Yes.
don't provide that ourselves. We
No.
are connected with Rebel News and their Fight the Fines, and we're connected with the JCCF and other organizations that are equipped to provide those legal services. So yeah, but you're absolutely right, Chris. It's
Yes.
it's a key part of what we do and the support we offer.
So the point is, the first interaction you'll ever have with anyone from the government, meaning someone who receives a paycheck from the government who's going to enforce the law, it won't be anyone else. It'll be someone from the government, as running a business, will cite you under one or more acts, and they will say, you're breaking the law. Here's a ticket for a fine. You don't pay the fine. You register to fight it. If you do ever, you could just do that yourself. You don't need to speak to legal counsel. Just register your intent to fight it. And if you ever receive a court date, then at that point, because you're in WeAreAllEssential, you'll engage with us, and we'll direct you to proper legal counsel, and it will be dealt with. And the more people who do this, the better. The more likely that out of 100 businesses that are cited, maybe 5 of them will somehow see the inside of a courtroom anytime soon. And the more people we have in court presenting evidence and asserting their charter rights, the more likely we are to knock down the lockdown. So what are your charter rights? And to be clear about Ontario, right now there's nearly 400,000 offenses in backlog. So, and the Supreme Court has found, they've opined on this many times, because a trial within a reasonable amount of time is a charter right under Section 11B of the Charter. So the Supreme Court has found in the lower court, provincial court, the government has a maximum of 18 months to bring the accused, bring the person charged with an offense to trial. So if you file for a court date, and then 18 months later, or before let's say 12 months later, they come up with a date and it's like at least 6 months in the future, it's blatantly unconstitutional. It'll be kicked on constitutional grounds. It'll either be withdrawn by the prosecutor, it should be, or again, through your counsel, will file a notice of constitutional question under 11B, or you could challenge the Reopening Ontario Act or whatever act that you're charged under and say it's unconstitutional and it should not stand. But it's very likely, at least in Ontario, you will never see the inside of a courtroom. And Randy Hillier, who sits in the legislature and protested in front of the legislature, was cited, and the JCCF immediately represented him, and they demanded a court date, and they haven't received one. So, and they keep getting Chris Sky's Quarantine Act case totally separate, kicked down. They keep kicking the can down the road because they do not want that ever heard in court because they have no chance of winning. So,
we've also heard of many other members within our network, following up to see when their court dates are, and they're not even in the system.
That's a huge, huge, huge concern because Adam Skelly, and there's another guy, Zach Boissonneau, who runs a gym in Ottawa, and again, Ontario only, but they just checked in the system to see, they just said, they registered to fight it, and then they just checked to kind of follow up and see where they are, or they can ever get a court date. And they found they weren't even registered, and the law requires them to register, or else there is no court date ever. And so Adam's charges
to register within 7 business days, are they not?
They whatever it is, there's a time limit. They have to register the offenses in court administratively, and if they don't do that, then the charges cannot be brought to court. So business owners who've been charged here, many of them forget about going to court. They haven't even been registered to go to court. They can't even. So anyway, so I'll go into the next thing, which is your actual charter rights, and I think we could wrap it up after that because these are your rights, and these are your. I gotta stress here, these are really your only rights that are protecting you from being thrown to the dogs. There really is nothing else you can cite. The Canadian Bill of Rights, you cannot cite that. I know some people like citing the Canadian Bill of Rights, that if the Emergencies Act were invoked, you could cite the Canadian Bill of Rights. If the Quarantine Act were suddenly somehow applied to businesses, maybe it will be. You could invoke the Bill of Rights, but you cannot invoke the Bill of Rights because it only applies to federal enactments. And I've said this till I'm blue in the face, and no one seems to want to listen to me on this because it expressly stipulates in the last part of the Bill of Rights, it refers to something emanating from the Parliament of Canada. It says laws of Canada, but they're really talking about the Government of Canada, the Parliament of Canada. If it does not emanate from the Government of Canada under Section 91 of the Constitution, 1867, then it's under Section 92. It's provincial. It's provincial. So the Canadian Bill of Rights does not apply to provincial enactments. So all the 3 things that I've been saying, in every province, it's 2 or 3 acts. There's emergency, there's health, and then there might be a COVID related measures act, as you have in BC and Ontario. The Bill of Rights does not apply, period. Doesn't apply. That's it. And I can say it until I'm blue in the face. I've argued it in Superior Court and withdrew it because I didn't want to die on that hill. So I'm speaking from someone who's actually argued it in court and withdrew it. Okay, so what do we have here? If you get a ticket, thus far no one has been arrested. If you were arrested, that's a separate thing, and that could be that could be under the criminal code. It has not happened thus far. If you're arrested,
civil, not criminal, right? Like
yeah.
When it comes to businesses opening up, it's a civil thing, not a criminal.
No. It is still criminal. It's quasi-criminal. It is quasi-criminal. You will appear, if you ever get in front of a court, it will be a POA court or provincial offenses. It'll be the low court in front of a justice of the peace, and you'll be summoned, as Alicia Herder has been summoned, and other people have been summoned before a justice of the peace, and then a court date is set, and all of that. So once it is quasi-criminal, people are fined. I guess they could definitely technically be imprisoned, but thus far, not a single business owner anywhere in Canada except Adam Skelly has been arrested. He's the only one in this entire country, as far as I know. Maybe I'm wrong about that. I know that some church pastors have been arrested.
Very recently.
But with respect to business owners, I'm not aware of any but Adam Skelly. And Adam Skelly was charged under the criminal code for trespassing his own property, mischief on his own property, and obstructing peace officer on his own property. So all of that stems from an illegal seizure of his property. It doesn't apply to anyone else. So other than that, if you are not arrested under the criminal code, it's provincial. And as long as it's provincial, you will get a ticket, you'll get a citation, and you can challenge it. So what are your rights? These are your bottom line rights. You have, under Section 2 of the Charter, fundamental freedoms. Again, fundamental freedoms. It's not just the Supreme Law of Canada. These are your most fundamental freedoms under the Supreme Law of Canada. What are your rights? Freedom of conscience and religion. A lot of times people look at this as just protecting churches. That's nonsense. It's conscience. It's the right to think what you want, when you want, without the state, using duress, putting using duress, using coercion to coerce your state of your freedom of conscience. That's Section A, the 2A. B is freedom of thought, belief, opinion, expression, including freedom of the press and other medium of communication. Critical, okay? If you want to express your complete disdain and disagreement and dissent with these blatantly illegal and unconstitutional measures, you have the right to do that. That is your freedom of, thought, belief, opinion, expression, bottom line. And that has been, people have come under extreme coercion with respect to conscience and under thought, belief, opinion, and expression, as well as 2C, which is freedom of peaceful assembly. Adam, no question, he advertised it continually. He said, "We are protesting. Yes, I'm opening. It's civil disobedient, but it is a damn protest. And we have the right to protest.
And there
we
were
have the
hundreds
right."
there that day, right? That were protesting with him. It wasn't like it
There
was
was a ton of people. It was a real protest. It's not
yeah,
some kind of a stunt. It was a lawful protest. It was a peaceful protest.
yeah.
You have that right under the charter, period. That's it. So that's Section 2C. The last one is freedom of association. This does not apply thus far to any challenges that I'm aware of. Maybe it could apply in terms of churches, but and maybe it has been invoked. I don't know in
I'd love
some
to
of
see it
the
applied
church challenges.
to gyms and fitness centers, right? Because like that is like-minded people coming together to,
Potentially,
you know,
potentially, but freedom of association is generally is applied to unions. So a
right.
union says, well, we have the right to collective bargaining and all this sort of stuff, and we have the right in the context of Section 2 of the Charter, a fundamental freedom of association. I raise this point, even though it's not something that has been invoked in Adam's challenge, which I will go over very briefly at the end. But this freedom of association is critical because We Are All Essential is an association. So if everyone comes up under the banner of We Are All Essential, we can invoke in a future legal action potentially down the road. We can invoke this freedom of association. The next charter right would be, and I've said stuff here, like I've said, assert your rights. I've just given an example. Again, it's not legal advice. It's a simple example of how do you invoke these rights? What can you possibly say? What options do you have?
I
So
love that you provided that. You know, you cited the section, and then you also gave the verbiage. Like, how would you actually
yeah,
exercise that right? What would you
yeah.
say? You know, which is really helpful for our members.
Yeah, so it's very simple for Section 2. You just say, my open business, or if it's a church place of worship, or if someone comes into the business, because a lot of times customers have been intimidated into coming into a business and supporting them, and also demonstrating they have the right to freedom of conscience, belief, thought, expression, and peaceful assembly by showing up in a business and shopping in civil disobedience. So my open business or place of worship or presence at the open business or place of worship is a protest against their unconstitutional lockdowns. I exercise my rights under Section 2 of the Charter, the freedom of conscience, or it would be religion if it's a church, thought, belief, opinion, expression, peaceful assembly, and association. That's it. And you could print this out and memorize it, or read off of it directly if you feel like it works for you. Otherwise, there are other things you can say. Those are not the only things you can say. These are just suggestions, and you have the right to say them. The next section, there's 3 sections. So sections 2, A, B, C, and D. Then there's section 7. This section 7 is arguably the most important section in the entire charter, because there are extra protections for people under section 7. A common thread runs through section 7 and then through 8, 9, 10, and 11 of the charter, and I believe also 15. And the Supreme Court's found that for decades since the charter was enacted. So this is a very important section that kind of secures the rest of these rights, especially rights that would impinge on your most fundamental choices, your life, liberty, and security of the person. That's what it specifically says in Section 7. So I'll read that to you. It says, Section 7, life, liberty, and security of the person. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. The principles of fundamental justice are pretty broad. There are a lot of them. And one of the principles of fundamental justice to be able is, I said, life, liberty. You're free. You're free to make fundamental choices that affect your own life. One of those is to make a damn living.
Right.
That's something without state interference. The Supreme Court has so held. Bottom line, this will be challenged very aggressively in court by everyone who's affected in this country. In the United States, it's something called substantive due process or procedural due process. It's called natural justice here. It's called fundamental justice. But it's covered, substantive due process or fundamental justice is under Section 7. And amongst those principles is the right to make free choices without state interference affecting one's life. So to quote this federal justice in Pennsylvania who ruled in favor of the applicants against the lockdown there, and they won, is he said, providing for your family, making a life for yourself, working to support yourself, making that choice. He said it's not just an economic good, it is a human good. Bottom line.
Yeah.
So that's Section 7, and I should also say under Section 7, with respect to the court's interpretation, you have extra rights under it. These are Section 7 rights. Said they affect life, liberty, and security of the person, and they don't really apply to businesses, but they apply to individuals, so small business owners, and the government has to demonstrate on an individual basis that the legislation is not overbroad or arbitrary or grossly disproportional or unconstitutionally vague. Mm-hmm. And they have to demonstrate that. That's something the government has to prove. The burden is on them for Section 7. Under Section 1, which I'm not going to go into, that's societal. It's essentially what's reasonable in a free and democratic society, reasonable limits on the charter and free and democratic society. And this is something that with the proper evidence, it cannot possibly be demonstrated that a complete suspension, almost permanent suspension of the charter rights and many sections of the charter, especially sections 2, 7, and 15, which I'm going to go into 15 in a minute, are somehow demonstrable in a free and democratic society. They completely are not, and we need but it will turn on the evidence. And under Section 7, that'll also turn on the evidence, but that is on an individual rather than societal basis. So how do you assert your rights under Section 7? Simple. My open business, or again, place of worship or presence at the open business or place of worship, is a protest against our unconstitutional lockdowns. Remember, that's the same verbiage as in Section 2. Then you say, I have the right to make a living or to buy, sell, participate in society, or to worship, and to my own life, liberty, and security. I have the right to fundamental justice, and I claim it. Again, this will be provided for you via the WeAreAllEssential website, which is critical for you to join our association and to read and know these rights and to print them out. Do whatever you want, staple them on your forehead, if whatever works for you. You need to know this stuff. And again, you can say whatever you like. There are many other takes on sections 2 and 7 and how to invoke your rights there. So the last one would be Section 15. What's Section 15? Equality before and under law, equality before and under the law and equal protection and benefit of the law. So Section 15, subsection 1 says, every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. And in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Now, this one is something where some lawyers have said, don't argue it. It's being argued in virtually every case in the United States. There, it's the 14th Amendment. It has equality rights in the 14th Amendment. Here's Section 15. It's very, very similar. There it's states' rights. Here it's national. It's every emanation of government. So including provincial, municipal, federal, everything. So in our case, it's the verbiage is similar, but there are different grounds of discrimination. And there's something called, I'm not going to get into it, comparator group analysis, and the Supreme Court has kind of moved away from that. So some lawyers here don't like the Section 15 argument because they're saying small business owners, well, that trait, that class will not be considered something under Section 15. But I disagree. And remember, I'm not a lawyer. It doesn't matter what I say. The legal team certainly agrees to argue that point. They've conducted, a vast analysis of the case law regarding that, and that is one of the things that is before the courts now in notice of constitutional question from Adam. So, so how do you assert your rights under Section 15? I and all other small business owners, or again places of worship, am not being treated equally under the law. I'm being extremely disadvantaged by the lockdowns. I've been robbed of my dignity and the ability to make a living. That's it. Now, this whole thing with dignity comes up a lot. Dignity generally does not come up in other countries. If some other countries, some other common law countries, it comes up sometimes. But in Canada, it is ingrained by the Supreme Court, by the Charter. Dignity comes up a lot. And essentially, if you're forced into complete despondency and dependency upon government, you cannot make a living for yourself. Your dignity is being utterly and completely destroyed. So Section 15 comes very much into play for small business owners who've been blatantly discriminated against without evidence. Without evidence, we can see. I can understand the first lockdown. I don't agree with it. I was against the first lockdown before it ever happened. I said, there's no evidence this will work. It's completely unconstitutional. It's complete garbage. But nevertheless, it happened. And at the time, maybe they could plead ignorance, say we were really scared, we didn't know about the virus. The second lockdown is criminal, in my opinion. It is outright. It's not just civilly liable. It's not just, it's not bad faith or abuse of power. It is criminal.
Yeah. And we're not even out of the second lockdown, and they're already talking about the third lockdown. So
yeah, it is blatantly, it is fraud. They know it's fraud. The evidence doesn't back it. In Ontario, they sat on the numbers regarding lockdowns all the way until November. The lockdowns were enacted in March 23rd. And they sat on these numbers all the way until November. Then the Bay brought their challenge, didn't invoke the Charter, didn't bring co-litigants, had great evidence, and were completely dismissed because the
Chris, you have frozen.
The absent of constitutional challenge, you're going to stand. Yeah.
You froze for just a second. You're talking about the Bay challenge and how they did.
Yeah.
Yeah.
Yeah, the Bay challenge. There was no evidence provided by the province all until November. They enacted the lockdowns March 23rd. November, literally 7.5 months later, they finally shared the numbers, and now they're very open with the numbers. And the numbers show that bars and restaurants, retailers, gyms as well, and I those three for sure. I also believe salons are included in there. There is simply zero. There's the evidence supporting
transmission in those areas. Yeah.
It's something like 1%, and even in those numbers, which you can look at, they're daily and weekly reports in Ontario, epidemiological numbers. And if you look at those numbers, you'll see that they mention two things. They mention cases and outbreaks, but there's literally no evidence at all provided by the province, zero, of how many hospitalizations or deaths, actual, real cases involving sickness, real sickness, not a positive test, but real sickness, hospitalization, and deaths. How many have been tied to any, small businesses? That is, bars, restaurants, retailers, gyms, churches, salons. How many? And I would say the evidence is zero thus far. It is zero, exactly zero. So that is the evidence that we have right now. In terms of Section 15, your equality rights, they are blatantly discriminating against you because they're not allowing you to open up, but they're allowing other businesses to open up. On what basis? Exactly. They don't have a basis. It's garbage.
Exactly.
So that's it. So I would say I can end it there and then simply say with respect to Adam's challenge, and you can look at this, we could post this as well. There's the notice of constitutional question is public, it's before the courts. We're arguing sections 2, 7, and 15, just as I've said here, but also sections 8 and 9. 8 is the right against unreasonable search and seizure. So in Adam's case, they seized his business without statutory authority. They just see it's a civil asset forfeiture. It specifically says under section 77.1 subsection 6 to 8 of the Health Protection and Promotion Act that only by order of a single justice of a superior court may be possession affected
Mm.
by the province. They cannot do it. It
Wow.
is blatantly illegal. It is a blatantly illegal exercise of statutory power and made in bad faith and abuse of power. So that's section 8. Again, it doesn't really apply to anyone else. Then there's section 9, which is arbitrary detention imprisonment. Again, we would argue that Adams, what they did with him was an arbitrary detention and imprisonment. And then there's also, we have other stuff in the original Constitution Act 1867. We have Section 91 arguments. That's essentially the province is encroaching on the federal law power, especially the criminal law power of the federal government. And that's blatant with respect to the arrests that they've made with various people, threatening people with criminal code charges, which is they cannot do absent a public health evil. If it's public health evil, it's federal, and if it's federal, they can't be provincial. That's not right.
Yeah.
And that's section 91. And then we have what else?
Well, honestly,
We
Chris,
have
like I would recommend that
yeah,
everyone check out the press conference that Adam did, because
yeah.
he went into quite a bit of detail about the case that they put forth, and it's powerful, and we're really confident in this case. And just for those that don't know, Adam Skelly is one of our founding members. You know, he was one of the first to lock arms with us, and so we're so pleased to see that he has, you know. Grateful to him for having taken a stand in the first place, all on his own, and yeah, now that he's got this court, this constitutional challenge in the works. I mean, this is going to really benefit all of us in the end. Fingers crossed. So yeah, no, I think that's plenty of detail, as you guys can see.
I'll
Chris,
mention one last thing, and
sure.
then I guess we can pretty much wrap this up. There's one other thing which is critical, which is argued in the notice of constitutional question. It's going to be argued in court upon application, and we'll be introducing expert evidence as well. And that's my involvement there in terms of looking at the stuff and bring it before the lawyers, and it's up to them to do what it is that they want to do with the evidence. So so then under part 3 in the Constitution Act in 1982, which contains under part 1 the charter. Part 3 says equalization and regional disparities. So it says commitment to promote equal opportunities. Section 36 subsection 1. Without altering the legislative authority of Parliament or of the provincial legislatures, or the rights of any of them with respect to the exercise of their legislative authority. Parliament and the legislatures, together with the Government of Canada and the provincial governments, are committed to, and then there's parts A, B, and C. Part A says promote equal opportunities for the well-being of Canadians. B, furthering economic development to reduce disparity to reduce disparity in opportunities. And C, providing essential public services of reasonable quality to all Canadians. And this one is a no-brainer. They've done everything they've done with respect to the lockdowns completely flies in the face of this section 36 subsection 1, because equal opportunities, well-being of Canadians, it destroys equal opportunities and destroys the well-being of Canadians. B,
Absolutely.
economic development to reduce disparity in opportunities, it destroys the opportunities. It dramatically increases the disparity in opportunities. And the last one, providing essential public services of reasonable quality to all Canadians, they're destroying that by introducing the lockdowns, which does precisely the opposite. So I'm gonna end there, say that kind of dovetails with section 15, and then under section 52, the charter is the supreme law of Canada. Anything that is inconsistent with the supreme law of Canada, which includes the charter in section 36, is of no force or effect. So that's what will be argued. That is what's being argued. That's the attorneys general are on notice of what's being argued. We have a great legal team of 4 lawyers, and down the road, There will be other litigants, and whether it's in this proceeding or some other proceeding, we're investigating that. But there will certainly be other people. So if other people have been shut down, other people are being bullied by law enforcement, and we're talking about not just tickets, but other actions. There's really only one other class order that's been issued in Ontario, and we are aware of them. But other than that, they're just being tickets. They've just been fines. So those fines can be challenged, but in terms of the lockdowns themselves, we are challenging the law directly. We're challenging the lockdown provisions of the Reopening Ontario Act, as well as the Regulation 8220, which affects the actual lockdowns under the Reopening Ontario Act and under the EMCPA, the emergency legislation. So I guess I'll leave it there and say that I've said this from all the way from April. I've said, do not consent, do not comply, do not obey, never give in, never give in, never give in. And that's it. If you do that, there are literally, to be clear, there are over 100 million of us in North America alone. Granted, a lot of people are scared, but they're staunchly against these measures. They know what's going on. That means there's still 268 million people at least, well, I would say at most 268 million people who are for the measures, but they can't get rid of 100 million people. There's nothing they can do with 100 million people who will never give in. So I would say that's what it comes down to. It's not even about the law. It is about who's going to actually give in or not, who is going to consent, comply, obey. If you refuse to consent, comply, obey, if you refuse to give in and you say, no matter what happens, I will never give in. I don't care. I will never give in. Nothing will happen to you. They cannot do something about 100 million people. They can make examples of Kellyanne Wolf and people like that who will get $40,000 per hour of illegal detention later on. That will happen. But until that happens, they can only make examples of people. If it takes, and other examples like this pastor who was arrested to go to jail, these people are all heroes. Yeah. And our freedom will depend on people who refuse to give in, who, no matter what threats that they receive, with respect to catch and release, blatantly illegal and unconstitutional catch and release policies to intimidate and bully people into compliance, whatever it takes, don't ever go along with it. Because you have a duty to disobey unjust laws, but you also have a duty to try this in a civil proceeding in court, to defend yourself in a criminal or quasi-criminal proceeding, and then to press the action in a civil proceeding to get relief. The first step is defend yourself in criminal, go against them in civil grounds to get relief from the court in an application, and get the monkey off your back before going after its evil trainer. Then go after the trainer in an action, a civil action or a class action. That is the last part, along with criminal. I've said criminal, and again, I'm not the only one who said this. A lot of very learned lawyers have talked about this, and I believe Lord Sumption has talked about some of this as well in the UK, a former justice of their Supreme Court. So there's a process, and the first process is defending yourself, then seeking relief, then going after them for damages, and then criminal as well on top of that. Those are 4 different proceedings, and they involve a lot of people, the individual stuff and then the societal stuff. So we have to come together under a common banner, under We Are All Essential. And no matter what you do, I would say, if they come after you, you have to go to court and you have to cite the law as written. And the law, because of the charter, we are in a unique position in Canada. We are the shining star. Other countries, New Zealand they have a supreme law, they have a Bill of Rights, but it's not supreme law. It could easily be overturned. In Australia, they don't have a Bill of Rights. In the UK, they don't have a Bill of Rights. In the United States, they have a Bill of Rights, but no constitutional damages. In other countries around the world, they don't have anything like that. We do. And the Supreme Court found one woman who refused to hold a handrail in the Montreal Metro. This is at the end of November 2019, got $20,000 for a half-hour illegal detention. That means $40,000 on the hour established by the Supreme Court of Canada, or highest legal authority with respect to the interpretation of law of the charter, where the charter wasn't even properly invoked. 10-year legal battle, $20,000.
Wow.
So you have rights. Use them. If you want to put a notice on your door under some other legal system, go ahead. But if men with guns come to you and they threaten you and they shut you down and they fine you, fight it. If they arrest you, fight it. Retain a lawyer. Fight it. Join us and fight it. In many cases, you'll be represented for free. There is absolutely no reason at all that anyone can have to say that they're not going to fight it within the legal system that we have today, where the evidence and the law are absolutely stacked in their favor.
Fantastic.
That's
Thank
it.
you so much, Chris. Oh my goodness. As you can see, you guys, he is just a wealth of knowledge, and he literally is doing his best to give you the Coles notes, holding back. We tried to keep this short, but this is one of the many people that are supporting our network, and all of you that, that are within our network and that choose to join us moving forward. um, like Chris was saying, we are stronger together. We have this association, and we can we can make a serious impact and create incredible change in our country when we band together, and we exercise our rights in these kinds of ways. And so I want to thank you so much, Chris, for sharing your experience, your knowledge, and yeah, we look forward to more businesses joining us in the near future, and starting to get behind the scenes, and doing some of these trainings, and reading some of these documents, and you'll be fully supported to understand them, and to gain that confidence to exercise them. So yeah, thank you so much, Chris, for all that you're doing for our network, and I hope that everyone found this valuable, and yeah, to be continued. We're just getting
Okay.
started, everybody.
Thank you.
Thanks,
Thank
y'all.
you, everyone. Thank you, Samantha.
Pleasure.
Okay.
Thank you.
Okay. Bye.